Good morning. My name is John Rogers, and I'm Environmental Manager of the Division of Oil, Gas, and Mining. I've been appointed by the Board of Oil, Gas, and Mining as a hearing examiner in this proceeding. Today is Wednesday, March 19th, 2025, and this is the time and place for the hearing examiner proceeding for docket number 2025-023, cause number 132-77. In a matter of the request for agency action of OVINTIV USA Inc. for an order pulling interest, including compulsory pulling of certain interests of certain non-consenting owners in the Alice 13-7 4-3-18-19-7H well in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River-Wasatch Formations, comprised of all sections 18 and 19, Township 4 South, Range 3 West, Uinta Special Meridian, Duchesne County, Utah. We are holding this hearing with the anchor position in the Department of Natural Resources building in Salt Lake City, Utah. We'll be hearing testimony and presentations in person and virtually, and proceedings will be broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? I see none here. Are there any online?
There are none online.
Okay, thank you, Matt. Let the record show no public respondents are present. We will now take appearance of counsel this time.
Fred McDonald of Counsel with Lear & Lear on behalf of Petitioner OVINTIV USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining. I'm also joined by Colton Goodridge with the division.
Assistant Attorney General Gary White on behalf of the hearing examiner.
Okay, thank you. I have received declarations regarding the matter from Mr. Peter Burns, Land Advisor, and Mr. Christopher Wall, Reservoir Engineer Advisor, both from OVINTIV. I have reviewed both declarations before this hearing. Both witnesses have been accepted as expert witnesses in past hearings. Do you wish to have them accepted as expert witnesses today in this hearing?
Yes, and again, just for clarification of the record, Mr. Burns is an expert in petroleum land management, and Mr. Wall is an expert in petroleum engineering.
Okay, thank you. Does the division have any objections to these declarations, or are these individuals being qualified as expert witnesses?
Objection.
Okay, thank you. They're each recognized as experts in their particular field of study and work for this matter. Mr. McDonald, are they present today online?
They are.
There they are. Okay, I'll swear them in at this time.
Thank you.
Please raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
I do.
For the record, the witnesses have affirmed yes to the previous statement. We now will proceed to Mr. McDonald for his presentation.
Thank you, Mr. Rogers. Before we begin, I want to confirm that you received Exhibit 110, which we submitted on Monday. That's simply the status of all the certified mailings to the compulsory pool party.
That's the one we reviewed yesterday. Yes.
And then yesterday, the board entered an order allowing the filing of revised Exhibit 7 and the supplement to Exhibit 69. The revised Exhibit 7 reflects changes in the gross working interests of the parties based on additional leasing that occurred.
Okay.
And supplement to Exhibit 69 was simply to show the status of the certified mailing of the notice of opportunity to participate to the party involved with that.
Okay, yes.
All right,
Received those.
The board, and by designation, Mr. Rogers as the hearing examiner, has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and implementing regulations at R649-28A and R649-2-9A. A copy of the request for agency action was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at their last address is disclosed by the relevant realty records and OVINTIV's internal records. In addition, the notice of the filing of the request in this hearing was also duly published in the Uinta Basin Standard on February 26, 2025, and in the Salt Lake Tribune on March 2nd, 2025. On March 10th, 2025, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the request and no other objections or responses to the request for timely file. This cause involves the compulsory pooling of the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of sections 18 and 19 of Township 4 South, Range 3 West in Duchesne County. That's reflected on Exhibit 3, as you can see. The drilling unit is approximately 2.5 miles southwest of the Bridgeland community and directly south of US 40. As shown on Exhibit 4, sections 18 and 19 are regular sections with the west half of each section comprised of lots. As a consequence, the drilling unit is 1,375.08 acres. The drilling unit was established for Lower Green River-Wasatch production by the board's order entered in clause number 130-07. As addressed in paragraph 16 of Mr. Burns' declaration, the 130-07 order was later modified by the 130-27 order to reorient the drilling unit from a stand-up to an extended laydown orientation. But that order also expressly provides that production allocation from the Alice 7H well, which is the well at issue, remains on the 130-07 stand-up basis.
Now, let me get it. The 07 was a laydown order.
No, it was a stand-up.
Stand-up. Okay, and the 27 converted it to,
An extended laydown of 3 sections.
okay.
But
The
board
Alice is,
stays on the stand-up,
is-
the original
okay.
drilling unit basis, yes.
were there any other wells drilled in that time or on?
No.
Okay, so that's the
This is
first
the
well.
only well.
Okay.
And we'll get to that
Okay.
with the testimony. True and correct copies of the 130-07 and 130-27 orders were collectively submitted as Exhibit 2 in this cause. As reflected in Exhibit 5 and is addressed in paragraph 15 of Mr. Burns' declaration, the Alice well was drilled as a long lateral horizontal well pursuant to the 130-07 order, with first production from the Uteland Butte member on January 28th, 2022. As reflected on Exhibit 6 and is addressed in paragraph 9 of Mr. Burns' declaration, there are 7 different oil and gas tracts in the drilling unit. All of them are privately owned in fee. As reflected on revised Exhibit 7 and is addressed in paragraph 10 of Mr. Burns' declaration, OVINTIV was the majority working interest owner in the drilling unit with approximately 86.8%, and several other parties whose aggregate gross working interest in the drilling unit is 9.56% more or less, signed joint operating agreements, thereby voluntarily pooling their interest, and which govern the consequences of their election with respect to the Alice well. There are 93 specific parties to be compulsory pooled, and 92 of them are to be declared as non-consenting owners in the Alice well, after the motion to amend, which I will make shortly. They are identified on pages 2 through 4 of the request, and in paragraph 17 through 107 and paragraph 111 of Mr. Burns' declaration. In the interest of brevity, I ask the hearing examiner to take administrative notice of those portions of those pleadings already of record in lieu of reciting all of those parties on the record right now.
I looked at the numerous ones, and the only question I have is who's the one that did not? You said there are 93, but
Ross Oil Company is deemed a consenting owner, but still needs to be compulsory pooled, which I will get to
okay.
in a little bit. As evidenced by Exhibits 8 through 21, 24 through 32, 34 through 37, 39 through 48, 50 through 58, 60 through 64, 66, 68 through 72, 74, 76 through 80, 82 through 84, 86 through 90, 92 through 97, and 99 through 103, and is addressed in paragraphs 18 through 30, 32, 34 through 40, 42, 44 through 47, 49 through 56, 58, 59, 61 through 74, 77, 80, 81, 80 through 87, 89, 91 through 98, 100 through 108, and 111 of Mr. Burns' declaration. The requisite notice of opportunity to participate in the Alice well was provided and received by the parties identified therein, but none formally and timely responded. As evidenced by Exhibits 22, 33, 38, 49, 65, 67, 73, and 91, and is addressed in paragraphs 31, 43, 48, 60, 76, 78, 82, and 91 of Mr. Burns' declaration. The parties identified therein, if known, were also sent the requisite notice of opportunity to participate in the Alice well to their last known addresses, but were either undeliverable or refused. Pursuant to the board's order entered on February 25th, 2025, all of those parties were provided notice by publication in the Uinta Basin Standard on February 26th and March 5th, but none timely or formally responded.
Just one point there. They didn't timely respond. Has any responded since that time deadline?
No, that's it. They haven't responded at all.
Okay.
In addition, as addressed in paragraphs 33, 41, 57, 75, 88, 90, and 102 of Mr. Burns' declaration, there were several parties who were unidentifiable and for whom no interest or addresses to provide the notice of opportunity to participate was discovered. Again, pursuant to the board's order entered on February 25th, all of those parties were provided notice by publication in the Uinta Basin Standard on February 26th and March 5th. But again, there was no response to the published notice. As addressed in paragraph 13 of Mr. Burns' declaration, since the filing of the request, the following parties named therein to be compulsory pooled and declared as non-consenting owners in the Alice well have granted leases to OVINTIV. This is Kimberly Hansen, Steve Godet, Rayleigh Brianne Mitchell Gallegos, Linda Knox Cusimano, Kyle F. Brown, and Wesley G. Howell Jr. As a consequence, OVINTIV moves to amend the request to eliminate them from being compulsory pooled and declared as non-consenting owners, and exhibits 23, 59, 75, 85, and 98 are no longer required and will not be submitted for admission. No exhibit 81 was ever filed, and there was no exhibit relating to Ms. Cusimano submitted because she had leased between the time of the filing of the request and the exhibits. As a consequence, and as reflected in revised Exhibit 7, and as addressed in paragraph 10 of Mr. Burns' declaration, the aggregate gross working interest of the parties to be compulsory pooled in the drilling unit is therefore now 3.611%, all of which remains unleased, including Ross Oil Company's consenting unleased interests, for which still requires compulsory pooling as outlined in paragraph 111 of Mr. Burns' declaration. Again, the main reason is because they've consented, but they did not necessarily sign the joint operating agreement. So we need to have them compulsory pool and sign the joint, or have the joint operating agreement apply to their interest.
You think they will sign eventually, or is that just?
I think that's a question that you'll need to ask Mr. Burns.
Okay.
In addition, although OVINTIV believes it has leased all successors and voluntarily pooled their interest pursuant to the pooling clauses contained in the leases, and is otherwise expressly identified in the request to be compulsory pooled, there are many additional parties claiming buy-through under certain decedents as identified in paragraph 109 of Mr. Burns' declaration, whose estates have not been probated or are incomplete in distribution of the mineral interest in the drilling unit. Again, pursuant to the board's order entered on February 25th, the requisite notice of opportunity to participate was also provided to them by publication in the Uinta Basin Standard on February 26th and March 5th. Again, no responses relating to any of those decedents were received. As addressed in paragraph 109 of Mr. Burns' declaration, Kirk B. Nielsen and Mark Kevin Sweatman were two of the decedents originally named in the request, but OVINTIV subsequently discovered their estates were actually probated in Utah, and their duly confirmed successors are leased or otherwise voluntarily pooled and participating in the Alice well. Consequently, we moved to amend the request to eliminate them from the list of the decedents and the compulsory pooling of any party claiming buy-through under their estates. Replacement Exhibit 105 in this cause is a true and correct copy of the affidavit of publication of the notice of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibit 106 in paragraph 118 of Mr. Burns' declaration, let me turn to that. The average weighted fee landowner's royalty as of the date of the spud of the Alice well was 19.021539%.
Well, only have a question for Mr. Burns.
Okay.
Okay, I'll wait for that.
As outlined in paragraph 116 of Mr. Burns' declaration, the parties shown on the certificate and supplemental certificates of service are all of the production interest owners within the subject drilling unit. Their names and addresses were derived from a title opinion with an effective date of February 8th, 2022, as supplemented by a record search by OVINTIV's contract landmen and OVINTIV's internal records. As the record will reflect, none of the parties identified in the request as amended today as being compulsory pooled and or is declared as non-consenting owners in this cause, timely filed a response or has made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, we move for the hearing examiner to enter an order of default against them and ask that it be ruled on at this point.
No problem with that.
Okay, so it's granted. Thank you. As reflected in Exhibit 107 in paragraphs 4 and 5 of Mr. Wall's declaration, the cost incurred in the drilling of the Alice well were reasonably and necessarily incurred and within reasonable variance of the authorization for expenditure sent out with the notices. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plugging and abandonment cost for the Alice well is $75,000. And finally, as reflected on Exhibits 108 and 109, in paragraph 7 and 8 of Mr. Wall's declaration, the risks assumed at the time of the spud of the Alice well are outlined on those exhibits. And as Mr. Wall will testify, justify the requisite or the requested risk assessment award to OVINTIV. With that, I'll commence my examination of Mr. Burns. Mr. Burns, would you please state your name and business address for the record?
Yes, Peter Burns, and OVINTIV's address is 4 Waterway Square Place, Suite 100 in the Woodlands, Texas, 77380.
And what's your current position with OVINTIV and how does it relate to this drilling unit?
I'm a land advisor with responsibility over this drilling unit, among others.
All right, just for the record, would you again state the corporate and bonding status of OVINTIV?
Sure. OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production, Inc. And also on January 22nd, 2025, OVINTIV closed the sale of its Uinta Basin assets to 4 Point Resources, LLC, which was retroactively effective back to October 1st of 2024. However, Newfield and OVINTIV owned and operated the subject well at all times relevant to this cause, and as such, OVINTIV remains the petitioner today.
All right, would you confirm for the record if it's 3 through 22, 24 through 58, 60 through 74, 76 through 80, 82 through 84, 86 through 97, 99 through 104, and 106 submitted in this cause were prepared by you or OVINTIV personnel or contractors with your review and input?
Yes.
Right. Would you also confirm for the record that the replacement exhibit 105 is an official business record of OVINTIV?
Yes, it is.
All right. Can you confirm for the record that you have read and confirm all the statements made in your declaration that are true and correct? Or if you require any modifications, please state them on the record at this time.
Yes, I believe it's true and correct, and not aware of any modifications at this time.
All right. Is it your expert opinion then that the terms and conditions of the joint operating agreement submitted as exhibits 103 and 104 are fair and reasonable and consistent with those executed by the other working interest owners covering this drilling unit as outlined in paragraph 114 of your declaration?
Yes.
Is it also your expert opinion that those terms and conditions are also commonly accepted by industry and in particular in the Uinta Basin with respect to horizontal well operations?
Yes.
Mr. Rogers, that concludes my examination. Mr. Burns.
Okay. Division?
Yeah, thanks. Mr. Burns, let's just stick on the JOAs really quick. So there's 2 JOAs. We have the separate one for Ross. In your affidavit, you indicate that you're uncertain if Ross signed the JOA. Could you just elaborate any more on that? How are you uncertain?
Well, we just, we sent it out with the proposal, the NOP, and not aware that we got anything back. And just with the sheer volume of mail that was required for this RAA and this, this project to force pool this well, just uncertain that we got it back. However, I think that exhibit 104 is essentially the same form that we sent to him. So, no changes in regard to that. So
the Ross JOA, as it's referred to, is for for all intents and purposes, the same terms and conditions as the previous JOA or the
Yes.
pending parties JOA?
Yes.
All right, thank you. Just a couple questions about some of the parties. You have your affidavit in front of you.
Yes.
I just wanted to ask about Melissa Bellon Garber. She's the PR for the estate of Kathleen Bellon. Paragraph 79, I believe, in your affidavit. Are you familiar with her situation?
I mean, somewhat, just difficult with how many owners are in this unit.
That's fine. Just take your time. I'll just ask. I just would like to know. Paragraph 79 talks about 3 separate owners that originally got was sent out notice for the well. Then subsequently, there was another notice sent out to her as PR. I just was wondering if you could explain that situation, if you recall it, and how that worked, because she was the party that was part of Supplement Exhibit 69 that was submitted, and it was indicated that she refused service as the PR.
Yeah, I think originally we mailed to all 3 of them, without understanding or not having seen any estate documents that appointed her as PR. And so as through further research, we discovered that she was PR, and so mailed to her in that capacity, just to ensure that we were, following proper procedures, which that was the February mailing. But yeah, that was refused, and we were not able to secure delivery.
Okay. However, I think the estate's named in the notice. Would that be correct, in the publication notice?
Yes, I believe so.
And then if we could just go to paragraph 99. It's for Tyler. Well, the person name is Tyler Dean Mitchell. But the notice by publication is for Kevin Hales Mitchell. Are you familiar with that scenario as well?
Not as familiar with this one, no.
So I guess my question there, let me just go to 99. Your affidavit indicates that Tyler Dean Mitchell is the apparent owner. I'm just curious why Tyler Dean Mitchell was not the party that then we subsequently had notice for.
I might be able to help clarify
Yeah,
that.
if you want to interject,
Yeah,
that'd be great.
I'm not testifying here, but I can
Sure.
kind of help clear up. He was sent the notice and he refused it. Okay.
Yeah.
Now, who is he? Tyler?
Tyler, yes. The Kevin Dean Mitchell was determined that he died in the interim, and that Tyler's claimed by through under his estate. I believe Kevin was also named directly in the publication notice.
Okay, so Kevin, it was his interest of record. Tyler is an heir.
Is a potential
Sure.
claimant.
Okay. All right. So then we have that one covered too. All right. Well, I have no further questions.
We go back, I see where that one worked, but the previous one, what was the name there?
I think it's paragraph 70.
What one was that, Andrew?
Oh, 79.
79.
Melissa Bellon Garber.
Yeah, I can help clarify that one too.
Okay.
A little bit more. If you carefully read Mr. Burns, and Mr. Burns, you correct me if I'm wrong here. The notices were sent out to these 3 parties as being the people who are claiming by through under the decedent. And you'll see it was received on October 7th. The probate proceedings weren't initiated until November. So that's why there's that situation. And then once it was determined that there was a probate and there was a personal representative appointed, they also sent the notice, and which she refused, and that was the supplement to Exhibit 69.
Well, then that leaves us a problem. She's a personal representative and she refuses to revert back to the three originals, or?
Well, and then, yeah, that would be the point, is that they're the people that are going to get it eventually, but she did refuse the acceptance of the notice of opportunity to participate as personal representative, but she received it as an individual
Also,
as well, yes.
So if this forced pulling matter goes through, then she'll be forced pulled and the group of them as a personal representative representing the three.
Anybody claiming buy through under that estate, yes.
Okay.
If it isn't those three as well.
Okay. Anything else, Andrew?
Nope.
Okay. I got a couple questions here. The first, you mentioned the OVINTIV 4-point transition. We're still in the name of OVINTIV. Is that eventually going to switch over, or is this just under the OVINTIV name because it originally drilled as OVINTIV? And made that for Mr. Burns.
Yeah, I mean, OVINTIV drilled the Alice well and operated it up until, closing of the sale to 4-point, which was in late January. Like just in the last 2 weeks, we got our change of operator approved from the BIA, which there's no BIA acreage in this DSU, but that is a component of the transition services that we get all these regulatory filings in place in 4-point's name as the official operator of all of our wells. So this transition services agreement runs through the next couple weeks, but yes, because OVINTIV drilled and operated this well, we are coming forward with this force pooling on this particular well.
If I may also add, it's also necessary for the revenue breakdown of reimbursements based on the risk assessments. So through to the date of closing, OVINTIV is entitled to those proceeds.
Mm-hmm.
And then 4-point will be, and they'll handle that internally.
Now, when's the date of closing? Is it January?
The closing was on January 22nd. Mr. Burns, when is the effective date of that transaction?
It's back to October 1st of 24.
So it's an accounting adjustment for the money. What OVINTIV gets as being the consenting owner up to that point, and then 4-point would get after that point.
Okay.
And again, these witnesses are the ones that are familiar with all of this, of what occurred. If we had 4-point be the petitioner, the witnesses wouldn't have any firsthand knowledge of what transpired here.
Okay. Okay, and also paragraph 96 on Mr. Burns' declaration. I'll get that. Am I down that wrong? Oh, I'm sorry, page 39. A lot of paper here. Okay, the average weighted fee landowner's royalty for the DSU is 19.021539, and that's based on the date of first spud. Now, when you get these changes that come in, is that rate fixed in time then? Even
Yes.
though it'll never change?
By statute, until if there's infill wells, but there's
Yeah.
not going to be here because it'll be a different drilling.
But that's fixed in time though,
Yes.
even though other people might choose to participate from the beginning to now.
Right, and then that's up to OVINTIV as far as the royalty that they negotiate on those other leases.
Okay. Okay. And maybe back to the, I asked this earlier, but I just want to clarify. The 13007 was stand-up units.
Correct.
And the 130-27 was laydowns. Is there going to be a problem with this one well being a stand-up and now other wells coming across? That might be more of a spacing question,
Well,
because that could cross that.
that would be a question for Mr. Wall, but again, the board, when they entered the 130-27 order, that was addressed to the board at that time, that there would not be interference
Okay.
because of the setbacks and where the other wells would be located. But Mr. Wall
Okay.
can also answer that question.
Okay.
That was part of the justification for the board allowing this to remain on a stand-up basis versus the lake.
Anything? Okay. I have no more questions for Mr. Burns.
Okay, thank you. With that, I'll commence my examination, Mr. Walden. Thank you, Mr. Burns. Mr. Wall, would you please state your name and business address for the record?
Yes, the name is Christopher Wall. Business address is 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
And what's your current position with OVINTIV, and how does it relate to this drilling unit at issue?
I am a reservoir engineering advisor for OVINTIV with jurisdiction over this DSU as well as others in the Uinta Basin.
All right, can you confirm for the record that exhibits 107 through 109 were prepared by you or OVINTIV personnel with your review and input?
Yes,
All right, can you also confirm for the record that you've read and that all statements made in your declaration are true and correct? Or if you require any modifications, please state them on the record at this time.
yes, and I do not require any modifications at this time.
All right, is it your expert opinion then that the actual cost of the Alice well at issue reflected in exhibit 107 were fair and reasonably incurred?
Yes,
Is it also your expert opinion that the Alice well was economically feasible to drill, as that term is utilized in the 13007 order?
yes,
Finally, is it your expert opinion that the risks shown and outlined in exhibits 108 and 109 as supplemented by your declaration justify imposition of a 300% risk assessment award and is fair and reasonable under these circumstances of this well?
yes.
All right, with that, Mr. Rogers, that concludes my examination, Mr. Wall.
Okay. Mr. Haynes?
Yeah, the division has no questions. Mr. Wall will allow questions answered through his declaration.
Okay. Couple of questions from me, and you probably heard these from before, Mr. Wall, but we're looking at the $75,000 P&A cost. That's been fairly consistent over the last several years as we've done that. Have we seen anything that would point to how close that is to being reality, or have you not really plugged any of these long horizontals?
Yeah, I don't know that we've plugged really any of these long laterals. However, you know, the cost difference between plugging, say, just a vertical and a long lateral is going to be about the same because of how you have to plug them. But so I don't think the $75,000 is out of line. I think that will continue to be the average, even if as we go to plug these wells.
Have you seen any costs or estimates from other companies in the area that have done any plugging?
No, not that I'm aware of.
Again, we see the 300% risk allocation. And can we go to exhibit 109? Oh, it's right up there. Okay, good. At the bottom, you say no issues occurred while drilling or completing this well. Are you finding that as you drill more and more of these, or, you know, this obviously was done in the past, as you drill more now, that this risk is going to be reduced, or do you think that remains consistent 300%?
Yeah, so our risk never really goes away. I mean, the risks do exist. As an industry, our ability to handle the risk changes. So yeah, you get better as you practice, but doesn't mean the risks go away.
But as you get better on handling this, do you see that, I guess I'm asking, the 300% has been kind of fixed over time. Do you see this, you get more knowledge and more ability in the area? You know, it says right here, no issues occurred while drilling or completing this well. Is that risk gone away, or is there still, you feel every time you drill, there's that risk?
No, I definitely think that every time we drill, we encounter these risks. And as to the 300% payout penalty, I think, you know, some of it, yes, we want to be able to recover some of the risks that we are faced with. It's also, you know, there's some incentive behind that to try and, you know, ask people to please lease, and other operators to join us in with the operating agreements and stuff. So there's the 300% is something that's pretty standard across the industry and across other assets, you know, in Texas, Colorado, et cetera. So this 300% payout penalty is something that's, you know, pretty broad and across the industry and all assets and all basins.
Thank you. Back to the date of first production was June 28th, 2022. 100% payout was reached in September 30th of 2023, approximately, would it be about 15 months? So where are we at now concerning almost the payout of 300%? Are we getting close? I mean, that 100% payout was pretty quick.
It was. We had some nice oil prices during that time period. I can't answer that. I don't really know how close we are to the 300% payout. I'm sorry.
Okay. All right. And then one more question, back to the spacing orders, the 07 and the 27. And perhaps if I looked at these in detail, but is there a vertical setback as well as a, you know, so the wells cross, but they can cross without interference as long as they're above a certain area? Or how are we going to handle that vertical, I mean, stand up versus horizontal?
I'd have to, I don't know, Mr. Wall, if you know what the setback is between the Alice well and the laydown well that was drilled or planned for drilling, I'd have to look at.
I'd have to go back and look at the order. I do not recall.
It should be in the
Okay, but
130.27 order.
It is accounted for, though.
Yes, yeah, it was at the time, because that was again, a specific concern of the board was to allow, if you're going to continue to allow this, that there wasn't going to be any communication or minimal interference between the wells.
Okay, I'll trust the board took care of that. I just, yeah. Okay. Yeah.
You have some people on cake during the presentation.
Okay. Yeah, I'd just like to take a quick break here. And at the beginning, I asked if there was anyone present. We've had two individuals come in. I wonder what their interest is here, and if we can understand if you're here for this matter or the next matter, or.
So I'm the executor of my mom's will, and we're just trying to figure out what we own, what we don't, if it's worth continuing, if it's not worth continuing. I just wanted to see where we are.
Do you know which matter you're here? There are two this morning.
Alice, we own in the Alice well, and also the Phillip well.
Okay. Do we know if she is in signed?
What's your
Mother's,
your mother's name?
Phyllis Parcell. It was with Lindsay, originally it was James Lane Lindsay, went to my grandfather, went to my mother, and now to me and my siblings.
Okay.
JL, you said?
Excuse me?
JL Lindsay?
James Lane.
Let's see.
That's one of the parties you have listed as one of the deceased parties.
Right, okay. Have you or your sister leased? Do you know?
If we,
To Newfield?
all I know is OVINTIV.
Okay, we'll have to, if it's okay with you, Mr. Rogers, I'd be happy to talk to her off the record. I don't believe they're being compulsory pooled necessarily.
Okay.
If they weren't identified, when did you initiate the probate of your mother's estate and I guess it was your grandfather then, right? J.L. Lindsay would be a grandfather?
He is a great grandfather.
Great grandfather, okay.
Should we take a break?
Either that or, Mr. Burns, are you still available?
Yes, I was just trying to write down some names. Can you spell those names, please?
James Lane. I am Joyce Havens.
Could you spell
Yes, JLYCE HAVENS. My mother was Phyllis Parcell. capital PHYLLIS, Parcel, capital PARCELL. My grandparents were Walter Rasband, capital WALTER, Rasband, capital RASBAND, and Elvira, capital ELIVIRA. And then my great grandfather was James Lyon Lindsay, capital JAMES, Lyon, capital LYON, and Lindsay, capital LINDSAY.
Okay, I will look here quickly to see if we have a lease or not.
You received a mailing though?
We received a mailing. My mom has received money from OVINTIV in the last 6 months.
Okay, my guess is that if they're leased, then they're not affected by being named as the compulsory pooling.
I want to figure that out though.
Let's take, hold on, and we got another.
I'll introduce myself too.
Yeah.
I'm Lou Jepson, LEW, Jepson, JEPPSON. I received royalties off Alice, and I did get a notice. I tried to log in this morning, but the login didn't work, so I hustled down here
Okay,
to find out what was going on.
okay, if you're leased, then you're personally affected by this. Okay, we're just requesting.
Yeah, I think that's right.
Yes.
I mean, you're not plugging anything here, are you?
No. This is simply dealing with people who have not agreed to.
Well, that's not us.
Right, yeah, but again, under the law, we're required to notify you of this proceeding, so that's why you received it.
Okay, all right.
Okay,
So,
Okay, why don't we take a break here and
yeah,
you'd like to talk with these two and with Mr. Burns, if that's, and
yeah, if we could go off the record.
yeah, let's go off the record for this time and then we'll come back.
Peter, do you have the spreadsheet?
Yes, I'm looking at our decks and the title opinion. So I'll be able to come up with an answer here shortly.
My expectation is you said your mother received money.
Mhm.
Okay. Do you know if she signed a lease?
I know that at first we were with WEM, Wasatch Energy Management.
Okay.
And that I think they leased my mom's property too.
Okay.
That's
Then what, if that's the case, if your mother leased or you're taken care of with that, then you should be okay. Wasatch Energy signed a joint operating agreement which helped pool that lease. So again, if they're leased, she shouldn't be adversely affected, but we'll verify. Okay.
So as for Mr. Jepson, I see we have a Lou Elton Jepson and Anna S. Jepson as joint tenants in the Alice well, and they're in pay status.
yeah,
This won't affect you at all.
okay. So is there any reason to hang around or should I just?
Yeah.
Not unless you want to be educated on
Yeah,
compulsory
if you want to
tools.
see how it works.
All right, thanks.
Thank you for showing up today.
And then we also have
Okay, back on the record, and Mr. Haynes, I believe I gave you the opportunity to question Mr. Wall. Okay, I want to make sure I didn't forget that. Okay, well, good. The division, as noted earlier, but I just want to reaffirm this, has filed a response of notice of non-opposition to the request of agency action dated March 10th, 2025. My understanding, the division has no objection to the request for agency action, but has reserved the right to update its response after their evidence cross-examined during this proceeding. Is that accurate, Mr. Haynes?
Yeah.
Okay. I now turn the time over to the division for their presentation.
Thank you. Yeah, as you indicated, the division filed a notice of non-opposition. And after hearing the testimony today, reviewing the declarations by both witnesses, we had a couple questions just as to notice that we satisfied that at this point, the petition has satisfied the regulatory statutory requirements that are part of their request today, and continue to have no opposition to this request.
Okay, will that be your closing statement then? Okay, we'll turn the time over to Mr. McDonald for his closing statement.
Thank you, Mr. Rogers. First of all, some housekeeping. I need to move for admission, and Julianne, I'll try and do this slowly and catch me if there's any issues with it. Move for admission of exhibits 1 through 6, revised exhibit 7, exhibits 8 through 22, exhibits 24 through 58, exhibits 60 through 68, exhibit 69 is supplemented, exhibits 70 through 74, exhibits 76 through 80, exhibits 82 through 84, exhibits 86 through 97, exhibits 99 through 104, replacement exhibit 105, and exhibits 106 through 110, as well as Mr. Burns and Mr. Wall's declarations.
And administrative notice.
The administrative notice of the pleadings as to the parties actually being compulsory pulled after amendment of our request.
Okay, Patty and Julianne, you get those, or are we still working on it? Good. Okay, division, do you have any objections to admitting those?
No objections.
Okay. We'll then admit those as presented.
Thank you. With that, Mr. Rogers, again, I know there was a lot of paperwork here. We certainly appreciate your effort and council's effort in going through everything. We do believe that the statutory and regulatory requirements have been satisfied. We believe that the relief is fair, reasonable, justified, and protects the relative rights of all parties. We ask that the request as amended this morning be approved, and that you make recommendations to the board for approval in that regard.
Okay.
And thank you again for your time, and also for the DNR IT people for allowing the virtual appearance by the witnesses.
Yeah. I'd like to take a few moments, go off the record, and meet with my counsel.
Sure.
One.
Back on the record. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented today, I found that OVINTIV has provided sufficient notice of opportunity to the non-consenting compulsory pooled owners and those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that the 300% non-consent penalty is fair and justified given the economic and geological conditions present with this well, and find that it would be appropriate to impose the requested non-consent penalty. I find that OVINTIV has met its burden of proof to show that they are entitled to forced pool the named interest and other relief requested in the request for agency action. Mr. McDonald, will you please prepare an order?
Certainly, and I will do it in a timely fashion so that council and yourself have plenty of time to review it before submission to the board.
Once we review that, I will present the findings and conclusions to the board next week at the board hearing. Any other comments before we close? If there are no issues, thank you for your participation and for the department staff that has allowed this matter to be presented virtually. We'll adjourn this proceeding at this time. Thank you. Off the record. Anyone need a break? Okay, then we will move forward.
If you give me a second and to get set up, that's okay.
Okay, Matt, tell me when we're ready.
We're just about there.
Okay, good.
Just one more minute. And so we don't need a countdown.
Okay, there you go. Good morning. My name is John Rogers, and I'm environmental manager with the Utah Division of Oil, Gas, and Mining. And I've been appointed by the Board of Oil, Gas, and Mining as the hearing examiner in this proceeding. Today is Wednesday, March 19th, 2025, and this is the time and place for the hearing examiner proceeding for docket number 2025-024, cause number 132-78. In the matter request for agency action of OVINTIV USA Inc. for order pooling interests, including a compulsory pooling of interests of certain non-consenting owners in the Phillip 13-7, 4-4-13-24-1H well in the drilling unit established for the production of oil and gas and associated hydrocarbons for the Lower Green River-Wasatch Formations, comprised of all sections 13 and 14, Township 4 South, Range 4 West, U.S.M Special Meridian, Duchesne County, Utah. We are holding this hearing at the anchor position in the Department of Natural Resource Building in Salt Lake City, Utah. We also will be hearing the testimonies and presentations in person and virtually, and the proceedings will be broadcast on the internet. Before we begin, are there any members of the public or respondents present that wish to comment on these proceedings? We have one. Would you like to identify yourself?
My name is Joyce Havens.
Okay, thank you. And any online?
No.
Okay, thank you, Matt. Okay, we'll take appearance to council at this time.
Fred McDonald of Counsel with Lear and Lear on behalf of petitioner OVINTIV USA Inc.
Assistant Attorney General Andrew Haynes on behalf of the Division of Oil, Gas, and Mining, and I'm also joined by Peter Pankey and Colton Goodrich of the division.
Assistant Attorney General Gary White on behalf of the hearing examiner.
Okay. I have received declarations regarding this matter from Mr. David Dale, Manager Rockies Land, and Mr. Christopher Wall, Reservoir Engineer Advisor, both from OVINTIV. I have reviewed both declarations before this hearing. Both these witnesses have been accepted as expert witnesses in the past. And Mr. McDonald, do you wish to have them accepted as experts today in this hearing?
Yes, and again, just for clarification of the records, Mr. Dale will be recognized as an expert in petroleum land management, and Mr. Wall will be recognized as an expert in petroleum engineering.
Okay, thank you. Does the division have any questions to these witnesses or the declarations provided by these individuals? Okay, thank you. They will each be recognized as experts in their field of study and work for this matter. Ms. McDonald, are they present here today?
They are. If gentlemen, would you turn on your cameras and please?
There we go. Good. We'll swear them in at this time.
Thank you.
Okay. Please raise your right hand. Do you solemnly swear that the testimony you shall give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Okay.
David, could you, are you muted or could you try it again?
Still not hearing
We're
you.
still not getting audio.
Can you hear me now?
Thank you.
Okay.
All right, would you again, that, your testimony as Mr. Rogers asked you to be sworn in?
I do.
Thank you.
For the record, the witnesses have affirmed yes to the previous statement. We will now proceed to Mr. McDonald for his presentation.
Thank you, Mr. Rogers. Before we begin, I want to confirm that you received Exhibit 96, which was submitted on Monday. Again, that's just the status of the certified mailings to the parties to be compulsory pooled if we had an address.
Okay, the updated one.
Right. And also, there was a revised Exhibit 6 that the board allowed the filing yesterday. Again, that's just an updated exhibit reflecting the gross working interest based on parties who have been leased.
That's the one.
That's the other one. So we went from 2.717 to 210. Yes, we got that.
All right, thank you. The board, and by designation, Mr. Rogers as the hearing examiner, has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-6.5 and implementing regulations at R649-2-8A and R649-29A. A copy of the request was mailed certified mailing to the known party sought to be compulsory pooled and mailed regular mail to all other production interest owners within the drilling unit at their last addresses disclosed by the relevant realty records and OVINTIV's internal records. In addition, notice of the filing of the request in this hearing was also duly published in the Uinta Basin Standard on February 26, 2025, and in the Salt Lake Tribune on March 2nd, 2025. On March 10th, 2025, the Division of Oil, Gas, and Mining filed a response expressing no objection to the granting of the request for agency action, and no other objections or responses to the request were timely filed. This cause is very similar to the one you just heard involving the compulsory pooling of the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of sections 13 and 24 of Township 4 South, Range 4 West, which is directly next to the drilling unit you just heard about. As reflected on Exhibits 4 and 5, Both sections are regular, and consequently the drilling unit is 1,280 acres. And as reflected on Exhibit 3, the drilling unit is located approximately 2.5 miles southwest of the Bridgeland community and directly south of US 40. The drilling unit, as was the last last matter that you just heard, was established under the board's order in 130-07. And as addressed in paragraph 15 of Mr. Dale's declaration, the 130-07 order was later modified by the 130-27 order to reorient the drilling unit from a stand-up orientation to a lay-down orientation, but expressly provides that the production allocation from the Phillip well at issue remains on the 130-07 stand-up drilling unit basis. A true and correct copy of the 130-07 and the 130-27 orders were collectively submitted as Exhibit 2 in this cause. As reflected on Exhibit 4, and as addressed in paragraph 14 of Mr. Dale's declaration, the Phillip well was drilled as a long lateral horizontal well pursuant to the 130-07 order, with first production from the U.S.M Butte member on January 28, 2022. As reflected in Exhibit 5 and as addressed in paragraph 8 of Mr. Dale's declaration, oil and gas ownership is uniform within each section and is owned privately, entirely in fee. As reflected on revised Exhibit 6 and as addressed in paragraph 9 of Mr. Dale's declaration, OVINTIV was the majority working interest owner in this drilling unit, approximately 90%, and several other parties whose aggregate gross working interest in the drilling unit is 7.89%, signed joint operating agreements, thereby voluntarily pooling their interest in which govern the consequences of their election as to the Phillips well. There are 86 specific parties to be compulsory pooled and declared as non-consenting owners in this well after the motion to amend, which I will make shortly. They are identified on pages 2 through 4 of the request and paragraphs 16 through 102 of Mr. Dale's declaration. In the interest of brevity, we ask the hearing examiner take administrative notice of those portions of those pleadings already of record in lieu of reciting all those parties right now.
Division, do you have any objection to that? Okay, so second.
Thank you. As evidenced by exhibits 7 through 22, 24 through 39, 41 through 43, 46 through 58, 60, 61, 63 through 66, 68 through 70, and 72 through 90, and is addressed in paragraphs 16, 17, 20 through 32, 34 through 39, 41 through 50, 52 through 54, 58 through 68, 70, 71, 73, 74, 76 through 78, 80, 82 through 84, and 86 through 90 of Mr. Dale's declaration. The requisite notice of opportunity to participate in the Phillip well was provided and received by the parties identified therein, but none have formally or timely responded to that notice. As evidenced by exhibits 40, 44, 45, 59, 62, and 71, and as addressed in paragraphs 51, 56, 57, 72, 75, and 85 of Mr. Dale's declaration, the parties identified therein, if known, were also sent the request or the requisite notice of opportunity to participate in the Phillips well to their last known addresses, but were either undeliverable or refused. Pursuant to the board's order entered on February 27, 2025, all of those parties were provided notice by publication in the Uinta Basin Standard on February 26th and March 5th, but none of them have formally timely responded. And just to address the date implication, the order was entered on the 27th, but in order to meet the deadlines for this hearing, I went ahead and published on the 26th as well as on March 5th. In addition, as addressed in paragraphs 19, 33, 55, 69, 79, 81, and 96 of Mr. Dale's declaration, there were several parties who were unidentifiable and or for whom no address to provide the notice of opportunity to participate was discovered. Again, pursuant to the board's order entered on February 27th, all of those parties were provided the notice by publication in the Uinta Basin Standard on February 26th, and March 5th, but none formally or timely responded to that published notice. As addressed in paragraph 12 of Mr. Dale's declaration, since the filing of the request, the following parties named therein to be compulsory pooled and declared as non-consenting owners in the Phillip well have since granted leases to OVINTIV. That's Kimberly Hansen and Ronald Dean Goodrich. As a consequence, OVINTIV moves to amend the request to eliminate them from being compulsory pooled, and exhibits 23 and 67 are no longer required and will not be submitted for admission into evidence. As a consequence, and as reflected on revised exhibit 6 and is addressed in paragraph 9 of Mr. Dale's declaration, the aggregate gross working interest of the parties to be compulsory pooled in the drilling unit is 2.103416%, all of which remain unleased. In addition, although OVINTIV believes it has leased all successors and voluntarily pooled their interest pursuant to the pooling clauses contained in their leases, and unless otherwise identified in the request to be compulsory pooled, there may be additional parties claiming by, through, or under certain decedents as identified in paragraph 104 of Mr. Dale's declaration, whose estates have not been probated in Utah or have incomplete probates to evidence the succession of the subject mineral interest in the drilling unit. Again, pursuant to the board's order on February 27th, the requisite notice of opportunity to participate was provided to them by publication in the Uinta Basin Standard on February 26th and March 5th. And again, no responses were ever received to those published notices. As addressed in paragraph 104 of Mr. Dale's declaration, Kurt B. Nielsen and Mark Kevin Sweatman were two of the decedents originally named in the request, but OVINTIV has subsequently discovered their estates were in fact probated in Utah, and their duly confirmed successors are leased or otherwise voluntarily pooled and participating in the Phillips well. Consequently, we similarly moved to amend the request to eliminate them from the list of the decedents and the compulsory pooling of any party claiming by, through, or under their estates. Replacement Exhibit 91 in this cause is a true and correct copy of the affidavit of publication of the notices of opportunity to participate received from the Uinta Basin Standard. As reflected on Exhibit 92 in paragraph 109 of Mr. Dale's declaration, the average weighted fee landowner's royalty as of the date of spud of the Phillip well was 18.998291%. As outlined in paragraph 110 of Mr. Dale's declaration, the parties shown on the certificate of service are all of the production interest owners in the drilling unit. Their names and addresses were derived from a title opinion with an effective date of February 8th, 2022, as supplemented by a record search by OVINTIV's contract landman and on OVINTIV's internal records. As the record will reflect, none of these parties identified in the request as amended today as being compulsory pooled and or declared as non-consenting owners in the Phillip well timely filed a response or have made an appearance today. Consequently, pursuant to Utah Administrative Code R 641-104-150 and R 641-108-400, OVINTIV moves to enter an order of default against them, and I ask that the hearing examiner will on that motion.
Accepted.
Thank you. As reflected in Exhibit 93.
I need a
Any
division.
objections?
I'm sorry. I'm going to ignore you down there.
As reflected on Exhibit 93 in paragraphs 4 and 5 of Mr. Wall's declaration, the cost incurred in the drilling of the Phillip well were reasonably and necessarily incurred and within reasonable variance of the AFE for this well. As outlined in paragraph 6 of Mr. Wall's declaration, the estimated plug and abandonment cost for the Phillip well is $75,000. Finally, as reflected on Exhibits 94 and 95 and paragraphs 7 and 8 of Mr. Wall's declaration, the risks assumed at the time of the spud of the Phillips well are outlined, justifying the 300% risk assessment award. With that, I will commence my examination of Mr. Dale. Mr. Dale, would you please state your name and business address for the record?
David Dale, with a business address of 4 Waterway Square, Woodlands, Texas, zip code 77378.
What is your current position with OVINTIV and how does it relate to this drilling unit?
Manager for the Rockies land team.
And you had supervision over this drilling unit among others?
Yes.
All right. Please state for the record the corporate and bonding status of OVINTIV and the change in operatorship that's occurring at this time.
Yes. OVINTIV is a Delaware corporation with its principal place of business or for the Rockies is in the Woodland, Texas. We're duly authorized to conduct business in Utah and fully bonded with state and federal agencies.
And what is the situation involving the sale to Fort Point? Could you just outline that for the record?
Yes, OVINTIV closed the sale of the Uinta Basin asset on January 22nd of 25. However, Newfield and OVINTIV owned these leasehold estates and drilled, operated, and produced the wellbore prior to that divestiture, and that wellbore that we're discussing today, the force pool.
All right, would you confirm for the record that exhibits 3 through 22, 24 through 66, 68 through 90, and 92 were prepared by you or Ovintiv personnel or contractors with your review and input?
Yes.
Can you also confirm for the record that replacement exhibit 91 is an official business record of Ovintiv?
Yes.
All right, would you please confirm for the record that you have read and can confirm that all statements made in your declaration are true and correct? Or
Yes.
if you have modifications, please state them at the record at this time.
I've read them and they're correct.
And no modifications are required?
No.
All right. Is it your expert opinion then that the terms and conditions of the joint operating agreement submitted as Exhibit 90 are fair and reasonable and consistent with those executed by the other working interest owners covering this drilling unit as outlined in paragraph 107 of your declaration?
Yes.
And also your expert opinion that those terms and conditions are consistent with those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes.
Mr. Rogers, that concludes my examination. Mr. Dale.
Okay, thank you. Division, do you have questions for this witness?
Mr. Dell's declaration answered most of our questions. I do have just a curiosity question as to, I mean, there's, I don't remember the exact amount of people, like 70, 80 people involved in this pooling. When I look at the lands, there's really nothing out there. Do you have an explanation why there's so many people finding minerals in this place?
I would need to look specifically at the title, but in many cases, it can go back to just large families with unprobated estates. And after 4 generations, it can certainly get pretty small quantums of interest.
Sure, thank you. That was just out of curiosity. But the division has no further questions. Yeah.
We had one theory on that. Is it possible because it's all fee land, 100%?
Yes.
And that makes it a little more complicated, or?
That's
And
true.
sections and feelings.
Yeah. Okay, I got a couple questions here, and I asked this in the last hearing, but I just want to reiterate, 100%, it was drilled or spudded on, no, first production on January 30th, 2022. 5 months later, June 28th, 2022, it had 100% payout. And obviously, it'd be interesting to know in future matters what that payout amount is, because I mean, once you reach through 100%, is this even worth, what's the benefit of doing a force pulling?
Well,
Go ahead, Mr. Dale.
oh, well, these wells did have a relatively quick payout, and they were really benefited by 2 factors. If we can all recall, inflation spiked middle to late of 2022. So we got the benefit of drilling these with cheaper costs that were not impacted by inflation. We also got high oil prices. I don't know if you guys recall, in 2022, we saw oil spike to over $90 to $100 a barrel for roughly a quarter to half the year. So that really helped the initial payout. Now, after we've received payout, we still carried all these parties through 100% payout. And so a forced pooling is really needed just to capture the difference between 100% and 300% for those parties who are unwilling to participate in the well. We're willing to offer the opportunity to participate, and they can sign a JOA or lease. But we really need to, as opposed to just continuing to carry so much interest, we're paying the bills but getting none of the revenue, right? Because we're putting it in suspense. We need to either lease them, pay their royalty, or force pool them, and then take that revenue share, and then they'll back in at 300%.
The other legal reason is that we have to set what the royalty is payable to these people under the compulsory pooling. We don't know until there's a compulsory pooling action, what the royalty is they're entitled to.
So you set the royalty rate at.
So the compulsory pooling is necessary to determine and do the accounting on the revenue, both as Mr. Dale explained, and also to the royalty owners or the unleased owners who are compulsory pooled to know what that percentage is.
Always a little interesting nuances of some things. Do you have questions? Okay. We'll move on to your next witness.
Thank you. Thank you, Mr. Dale. Mr. Wall, would you please state your name and business address for the record?
Yes, it's Christopher Wall with a business address of 4 Waterway Square Place Drive, Suite 100, The Woodlands, Texas 77380.
And what's your current position with OVINTIV and how does it relate to this drilling unit?
I'm a reservoir engineering advisor with jurisdiction over this GSU as well as others in the Uinta Basin.
All right, would you confirm for the record that exhibits 93 through 95, as shown on the PowerPoint there, were prepared by you or OVINTIV personnel with your review and input?
Yes.
All right, can you also confirm for the record that you have read and can confirm all of the statements made in your declaration are true and correct, or if any modifications are required, please state them on the record at this time.
Yes, and no modifications are required at this time.
Right, is it your expert opinion then that the actual cost of the subject well at issue reflected in Exhibit 93 were fair and reasonably and necessarily incurred?
Yes.
Also, your expert opinion that the Phillip well was economically feasible to drill as that term is utilized in the 13007 order?
Yes.
Finally, is it your expert opinion that the risk outlined on Exhibits 94 and 95 as supplemented by your declaration justify imposition of a 300 risk assessment award and is fair and reasonable under the circumstances of this well?
Yes.
All right, Mr. Rogers, that concludes my examination, Mr. Wall.
Okay. Division, do you have questions for this witness?
Division has no questions for Mr. Wall.
Okay, thank you. Well, I can consult with my attorney. I'm sorry for the delay there, but I do have one question. If we go to the paragraph 90 on the request for agency action.
Oh, yes. Okay.
That's kind of unique. I've never seen like that before where it says, I'll read it. It says, the IRI owned an undivided oil and gas interest in the DSU by mineral quitclaim deed dated October 24, 2017, and recorded on November 3rd, 2017. Entry as James N. Sheffield and Gordon A. Nebeker, a member and board of directors and vice president, respectively, of IRI, a dissolved Utah corporation. Okay, they then assigned 70% of this mineral value to the state treasurer as unclaimed property. Explain what was going on there.
I'll be happy to. This is more of a legal question.
Okay.
And IRI stands for Intermountain Resources, Inc.
Okay.
Okay. This has come up several times in front of the board, as well as in the prior matter. The problem is, as title examiners, and I'm not the only one, other title examiners have questioned this, the state treasurer as unclaimed property only has the statutory authority to accept proceeds, not real property. And so we deem, as a title examiner, that that's an invalid conveyance that was made to the state treasurer. And who's entitled to it are the stockholders of the company is dissolved, but we've been unable to determine that. OVINTIV, as outlined in Mr. Dale's declaration, made inquiry of several parties. And
So there could be hundreds of them.
it could be anybody.
Yeah.
So that's why they were named as anybody claiming by, through, or under Intermountain Resources, Inc. They're unknown, and so that's why the notice was published to them. And what has happened is that money will still remain in suspense. And once the money is occurred after the 3-year period, then it would be turned over to the state treasurer as money as opposed to property owned by the state treasurer.
But it'd not be turned over in a name, it'd be turned over as a stockholder, because you wouldn't know those names, would you?
Right, it would be the unknown stockholders or shareholders of Intermountain Resources,
And for
Inc.
them to get any resources, they'd have to prove.
They'd
their
have to
ownership
prove their
there, okay.
stock ownership. Yeah.
It's just something, maybe I've seen it before, but it was kind of unique. I noticed.
It is, and again, it's because of this question of, does the state treasurer have the authority to take hold of real property versus proceeds?
And they've not pushed back against that? Well, it's out of the, I'm just kind of curious.
They were notified of everything and never responded to it, so that's the reason we did this, and it would remain in suspense until that's resolved.
Okay, thank you.
Mhm.
We both were wondering about that, so.
Yes.
Okay,
Any other questions for Mr. Wall, or?
no, I think most of the questions I had, we answered in the last time, and I felt comfortable with that. The division, turn over for your presentation.
Sure. At the division, we reviewed the declarations, reviewed the requests and the exhibits. After reviewing all the information, the division satisfied that the statutory and regulatory obligations were met, and we have no opposition to this request.
Okay. Well, that will serve as your closing statement then? Okay, great. I'll turn time over to Mr. McDonald for your closing statement.
Thank you, Mr. Rogers. Again, for housekeeping purposes, and Julianne, I'll try and go slow and make sure if I catch everything here. Going to move for admission of exhibits 1 through 5, revised exhibits 6, exhibits 7 through 22, exhibits 24 through 66, exhibits 68 through 90, replacement exhibit 91, exhibits 93 through 96, Mr. Dale and Mr. Wall's declarations, and then also the administrative notice by the hearing examiner of the parties to be compulsory pooled, as identified in the pleadings as amended by my motion today.
Okay. Division, do you have any objections to that? Okay, so admitted.
Thank you. With that, again, as Mr. Haynes stated, we believe that the statutory and regulatory requirements have been satisfied. We believe the requested relief is fair, reasonable, and justified, and protective of the correlative rights of all parties. We ask that the request, that you as the hearing examiner make the recommendations to the board that the request as amended this morning be approved. We certainly, again, thank you, Mr. Rogers and council. There's a lot of paperwork, I know, involved with this, and the time that it takes to go through it. We appreciate your efforts. And again, we thank the IT people for their allowing witnesses to appear virtually today. Fairly seamless. So with that, thank you.
Ma'am,
Yes,
do you have any questions at this time?
I think I will ask my questions to the open guy here.
Mr. McDonald, President McDonald.
Mr. McDonald, there we go. Thank you.
Well, this time I go off the record and I like to consult with my attorney for a little bit. Okay, back on the record. Having reviewed the request for agency action, all exhibits, and having considered the evidence presented here today, I find that OVINTIV has provided sufficient notice of opportunity to the non-consenting compulsory pool owners, and that those owners identified in the request for agency action did not timely elect to participate in the wells and therefore should be deemed non-consenting parties. I find that 300% non-consent penalty is fair and justified given the economic and geological conditions present with this well, and find that it would be appropriate to impose the request non-consent penalty. I find that OVINTIV has met its burden of proof to show that they are entitled to forced pooling of the named interest and other relief requested in the request for agency action. Mr. McDonald, will you please prepare the order?
Certainly, and I'll prepare the time for council and yourself to review ahead of the board hearing.
Once we review it, we will then present this to the board hearing next Wednesday. And any other comments before we close? Okay, if there are no more comments, I thank you for your participation and for the department staff that allowed this matter to go forth and presented virtually. We will adjourn this meeting at this time. Thank you.